Morning, everyone. Welcome to the First District Court of Appeals. We have three cases set for argument today. I will state the case, and if the attorneys will, please state your appearances and your readiness to proceed. The first case up for argument is case number C-240452, Mills Fence Company versus Michael, is it Kinney? Kinney.
Josh Davidson for the balance of the Kinneys.
Good morning.
Brian Schultz for Elise.
Good morning. The second case we have set today is C-240408, State of Ohio versus Tyshawn Barker.
Ron Springer for the state of Ohio.
Good morning.
William Gallagher on behalf of Mr. Barker, and I'm ready to proceed.
Good morning. And the final case for argument today is C-240420, State of Ohio versus Kenyatta Stokes.
Good morning, Your Honor. Brian Perkins on behalf of the appellant, Ms. Stokes, ready to proceed.
And Your Honor, Ron Springer again, I'll be filling in for Mr. Wessels, who will not be able to make it.
All right, thank you. All right, so our first case, Mills Fence. Ready when you are. Would you like to set any time or reserve any time for rebuttal?
Please, Your Honor.
How much?
2 minutes.
Just two? Okay.
May it please the court. Good morning, Your Honor. This is actually an unusual case. I think fundamentally the issue that is before the court is when is the director or a shareholder of a corporation, in this case directors of a nonprofit corporation, personally liable to their creditors. The decision in this case from the trial court is kind of odd and made things a little bit more complicated to make the argument, but the essential provision in the revised code is 170255A, which specifically makes clear that the members and directors and the officers of corporations shall not be personally liable for any obligation of a corporation. So we start with the principle that piercing a corporate veil generally is a very limited, very difficult hurdle to jump, very limited remedy. And we have the code specifically saying we're not going to hold directors of a corporation personally liable for the debts of the corporation.
Is that the only way to do it, by piercing the corporate veil?
No, not at all, Your Honor, and that's kind of the conundrum in this case. In this case, the issue is that the directors of the corporation on behalf of the corporation sold basically the corporation's primary asset, which was a piece of real property. Excuse me. Liquidated it and retained the proceeds from sale for themselves. And the remedy, and the most appropriate remedy by far, is the Uniform Fraudulent Transfer Act. So if a creditor believes that the corporation had an asset and that the asset of the corporation that could have been used to satisfy the debts of the corporation had been transferred to an individual or another entity, the Uniform Fraudulent Transfer Act provides that remedy.
Do you even need to get to the Uniform Fraudulent Transfer Act? Couldn't you just do it under the provisions of the Not-for-Profit Corporation Code?
I think you have to use the Uniform Fraudulent Transfer Act in the absence of a significant tort that rises to the level of fraud or some criminal or illegal activity.
Doesn't 1702.54 provide for such an action?
So I'm glad you asked that question. It does. It provides a cause of action for the corporation against its directors. So 1702.55 has to be read in the context of 1702.30 has to be read in the context of 55, and I think you're referring to 1702.55J.
Well, 55J basically says, except as provided by law.
Correct. But it's
And then is there some other law other than 1702 that provides for personal liability?
So my answer would be there are two effective remedies for creditors when they believe that a corporation should have satisfied a debt and they want to get at the directors or shareholders of a corporation. The first, as I already said, is the Uniform Fraudulent Transfer Act, if the fact we're talking about a fraudulent transfer. The other is piercing the corporate veil in the event that there's been a tort that rises to the level of an egregious act. Other than that, the answer is no. And You know, I made reference, I cited several bankruptcy courts in my brief, and I think I just want to raise that issue very quickly, which is the bankruptcy code makes very clear that any fraudulent transfer, so if there's an actual fraud perpetrated by a debtor, then that debt may not be dischargeable. So anytime the directors or the shareholders of a corporation or officers of a corporation file individual bankruptcies to shield themselves from their personal liability for corporate debts, the corporate creditors would want to reach those individuals, claim that the debt is non-dischargeable based on some act of fraud. And so bankruptcy courts in both the Ohio and northern and southern districts have addressed this issue extensively. The case law is very, very clear. The 11th District, also citing the Ohio Supreme Court, has affirmed that what the bankruptcy courts have said, which is that there is no fiduciary duty that directors of a corporation owe to their creditors. And
So
those-
is that kind of the rule that you want out of us, is to follow the 11th District and say there cannot be a breach of fiduciary duty to someone outside of the corporation?
Absolutely. Yeah. And in the context of a fiduciary duty, and then I'll get back to your first question, which I think is a very important question. In the context of a fiduciary duty, I mean, we have to think about what a fiduciary duty is, right? The highest duty of loyalty owed under law. It's a special relationship between parties, and to suggest that there's a special relationship generally between the directors of a corporation and their creditors is kind of nonsense. And in the context of this case, this is a really simple contract case, right? Mills Fence constructs a fence, there's a contract, there's an invoice, there's a mechanics lien, and there's non-payment.
How old is that original debt?
It's considerably old enough that unfortunately the change in the statute of limitations in 21 doesn't apply. So I think it was 13 off the top of my head. So the fence was in the neighborhood of 2013. Mechanics lien is filed, and it expires after 6 years. And so with respect to this specific case, I mean, that's to me a very, very important fact. And the trial court wrestled with that issue, which is Mills Fence, who's here now asking for a very extraordinary remedy against the directors of the corporation, had the ability to pursue its claim against the corporation for a long time. They allowed a mechanics lien to lapse. 6 years is how long it takes before a mechanics lien lapses under the Ohio Revised Code. So for 6 years, they could have foreclosed their mechanics lien against the specific asset that they're claiming that the directors transferred in violation of their alleged fiduciary duty.
So help me understand, it seems like the trial court's decision kind of hinged on the thought that your clients didn't present any evidence that they actually were owed this debt from the company. Because I guess what I understood the judge to say is that if they had produced such evidence, then that would have been fine for them to take this money. But they didn't, and therefore they owe the money to the Mills Fence?
So that's the question of the day, Your Honor. My reading of the court's oral decision at the end of trial is that the judge did a fraudulent transfer analysis. And the problem with the judge doing a fraudulent transfer analysis in this case is that Mills Fence had asked for an opportunity for the third time to amend its complaint and add a claim for fraudulent transfer, which would have been the correct claim, not conceding that it was a valid claim, not conceding that the Kinneys wouldn't have prevailed upon that claim, and we feel 100% sure. And just to cut to the chase, as I explained to the trial court, the insolvency issue is a big deal, right? Mills Fence kept talking about the fact that the corporation, Arras, that Arras was in insolvency or in the zone of insolvency, but the problem is the only way that it was in insolvency is if the debt is actually owed to the Kinneys. Without the debt that was owed to the Kinneys, there was no insolvency. The corporation was solvent.
Because the debt to them was hundreds of thousands of
Correct.
dollars. Right.
Correct, and they reported, and there's plenty of evidence, and I've cited some of it on the record. There was plenty, and all of it uncontroverted. There's plenty of evidence that the Kinneys reported over $500,000 of debt owed to them personally to the Attorney General. They provided a lot of evidence of that debt in discovery. There were resolutions memorializing that debt that were presented as evidence. The problem is, once the trial judge said, no, I'm not going to allow the complaint to be amended to add this UFTA claim, I didn't present evidence that would have been necessary to defend a UFTA claim because it wasn't any longer before the court.
So you're saying her analysis was basically the type of analysis that you would make under a fraudulent transfer claim?
Partially. I mean, the problem with the UFTA as adopted by Ohio, and you know, I deal with it on a regular basis, is it's a long, complicated statute with a lot of factors to consider in determining. So insolvency is the primary factor, but not the only factor. So it's a pretty complicated, long, involved statute. And the trial judge didn't get to that. It felt more like it was, hey, everybody has done something wrong here. Let's just figure out who did something more wrong. So it was the beginnings of a UFTA analysis. So she starts going through, well, geez, if the debt's actually owed to the Kinneys, well, then everything's fine. Right?
Was there evidence of this founder's loan that was presented to the trial court?
Yes, Your Honor.
What was that evidence?
Promissory notes, multiple promissory notes and resolutions.
So you're saying, first of all, that her factual finding was contrary to the evidence presented, and second of all, the factual finding didn't matter under the facts of the complaint here.
See, it's getting as convoluted as I figured it would. So what the trial judge would have liked to have seen would be canceled checks and credit card charges and receipts and invoices and all the things you would normally use to evidence a debt, and particularly funds extended for which you're anticipating repayment. And I wasn't going to waste trial time putting all that evidence in when it wasn't before the court, right? The complaint was very specific. The judge had already said, no, you can't pursue a fraudulent transfer claim. So what we're before the court upon is a breach of fiduciary duty claim and a piercing the corporate veil claim. And the problem with the piercing the corporate veil claim is this court has already decided in White, I've got the citation, but in White, this court said that piercing the corporate veil is not the sword, right? You have to have the underlying tort. Dombrowski set forth from the Ohio Supreme Court the standard to determine when that tort rises to a level sufficient to pierce the corporate veil, which it just doesn't in this case. So rather than address any of that in her recitation at the conclusion of trial, the judge, I mean, she briefly touched on important issues, including she didn't think that the first prong of Dombrowski had been met. She felt that there was no evidence that the directors of the corporation had operated the corporation in such a manner as to, that piercing the corporate veil would be appropriate as an alter ego. So that's the first thing. She went through an analysis and said, well, there's not any evidence here that the directors were operating the corporation as an alter ego to protect themselves.
If this founder's loan had been determined to be fraudulent, would that change your analysis?
So it wouldn't, Your Honor, and I'll tell you why. The bottom line is how and when directors can be held individually liable for debt that the corporation owes. So if the founders' loans were fraudulent, that would be certainly a badge that's important evidentiary, from an evidentiary standpoint, in a UFTA claim. So if Mills Fence is arguing that the Kinneys fraudulently transferred this real estate, particularly they didn't fraudulently transfer the real estate, but they fraudulently transferred the proceeds from the sale of the real estate to themselves, would be the allegation. Then, when you're going through the UFTA statute, making the argument that, well, because the Kinneys would defend it by saying, we owed the money, right? We were a creditor, we were entitled to the money. There were resolutions passed making us a priority creditor, so this money is ours. So to answer your question, in that analysis, if Mills Fence were able to prove that these resolutions were fraudulent or were just not appropriate under the law, that would be an element of proving the case of a fraudulent transfer. But in terms of piercing the corporate veil, my answer is no.
And you are at your time if you want to reserve 2 minutes.
Yes.
I'm going to check with my colleagues if they had any further questions. Okay.
Thank you.
Yes. Good morning.
Morning, Your Honors. May it please the Court. Under Ohio law, there's a well-established duty that corporate directors owe to creditors under certain circumstances. And this duty comes from binding on-point Supreme Court precedent holding that as a corporation winds up, it has to settle the corporation's debts.
So it doesn't come from the statute?
It does come from the statute. It does come from the statute partially.
Because you make a statutory argument as well, so.
Yeah, and so that common sense, common law duty is codified in the statute as well.
And with the common law duty, does that come from the K-machine? Is that the trust theory of the distribution of the assets of the
It's-
corporation?
So the trust, my understanding of the trust fund doctrine is that it's one sort of particular expression of this common law duty that corporate directors owe. But the corporate directors, this goes back to the Thomas V. Matthews case, excuse me, that says where a corporation is insolvent or threatened with insolvency, the directors stand in the relation of trustees to the creditors, and they are not permitted to divert assets from the payment of its debts.
How do you square that with the no personal liability provision in 170255?
Because 170255 also says that it doesn't prevent creditors from bringing common law actions against the corporation or creditors.
Where does it say that?
I don't know the exact subsection off the top of my head, but I believe it's the last subsection that says nothing in the foregoing shall prevent a creditor from bringing.
So it seems like that almost makes meaningless the protection of no personal liability for directors or members.
Well, I do agree with Mr. Davidson that there has to be some kind of tort, right? There has to be a breach of a duty, right? What we disagree on is whether or not the duty actually exists in this case, right? And what he's saying is that the statute has fully abrogated the common law duties that are talked about, as far back as Thomas V. Matthews, but then they're, expressed in K-machine, right? And K-machine says very explicitly, the General Assembly, in enacting the General Corporation Act, so that's chapters 1701 and chapter 1702, which governs nonprofit corporations, the General Assembly intended that the assets of a dissolved insolvent corporation should be preserved for the benefit of all of its creditors. So that's not just...
Aren't they preserved, though, through the dissolution process?
They should be. That's right. And I think that's what Mills Fence's argument was at trial, was that had this corporation been dissolved properly, had there been some kind of judicial oversight, receivership, formal bankruptcy or something like that, that would have preserved all of the claims of creditors. The point is that what the Kinneys did was they decided unilaterally to say that not only were they owed hundreds of thousands of dollars in these founders' loans, what they said was that we get priority, and that priority is an operation of law. They can't just pass a resolution that says we are allowed to pay ourselves first. The holding in K-machine says that the assets of the dissolved insolvent corporation should be preserved for the benefit of its creditors, each in proportion to their claim. Right?
Isn't that claim something they would make under the corporation code, under 1702?
You mean Mills Fence would make under the corporation code?
They would bring an action and say you're in violation if there was a formal dissolution, and any payment to the members should be prevented until the creditors are paid. And
I think that is one way to do it. I think what we're saying is that, so Mr. Davidson identified 2 ways. He thinks that there's only 2. I think that there's at least 5 different ways that I've seen in the case law where you can do it, and one of the ways is the breach of fiduciary duty action. I think the other way that was not really discussed in the briefing, but in the Franklin Management case, is that you can just bring a garnishment proceeding directly against the directors of a corporation. So there's a number of different ways to do this, and I think that there's one of the arguments that Mills Fence has been kind of up against from day one with the Kinneys is that, use the magic words or use the right process or something like that. But the issue is that the process is not at all clear until discovery takes place and until we actually know what was transferred. My client wasn't even really aware that the property had been transferred until after the mechanics lien had lapsed on the property, which was something that surprised them.
Why did it take them so long to collect on this contract debt from 2013 or 15?
It's 2015, and that I don't know, Your Honor. I'm not sure why they waited so long.
Is the allegation that this founder's loan was fraudulent?
The allegation is that it could very well be.
Was there evidence of this founder's loan, as counsel has indicated?
So, no, I don't believe that there was. So the Kinneys produced some promissory notes, but the promissory notes don't have amounts in them. At least the main promissory note that they were claiming against, they didn't have an amount in it. It was a revolving line of credit, right? And this is one of the things that the trial court really took as a very sort of serious factual finding, was that this revolving line of credit would be evidenced by something on a balance sheet. There would be some evidence of funding the loan and then some evidence of paying the loan back, right? And that's the kind of evidence that you generally need for any loan, but in particular, a revolving line of credit with no amount, right? Because with the revolving line of credit, what it enabled the Kinneys to do was to go to the Secretary of State and say, we have this loan and we're owed, I can't remember if in the Secretary of State report they said $500,000 or $600,000, but we're owed $500,000 or $600,000. So we're going to take all of the assets out of a nonprofit corporation, which, by law any excess is supposed to go to the beneficial cause. It's not just supposed to go to the directors. And they really had no evidence of it. And so that's
the fraud.
well, again, Your Honor, I'm not going to say that it is or is not fraud. What I'm going to say is that they did not have the records to produce. They said that they either destroyed or lost them in the dissolution process of Eris. They
But I'm
said,
trying to understand why this matters, because the judge also said if they did have the records, then they would have been right to be able to pay themselves.
yeah, and so I think, and that also comes out of the K-machine part of the holding in proportion to the claim, right? So the way that I understand Judge Marsh's holding
Okay.
was that there was a duty and it was breached. And the breach of that duty means it's not necessarily that the Kinneys would have had to have refunded all of the money. They would have to have given Mills Fence what it was owed in proportion
So
to.
the duty, they had a duty, but wasn't the duty to the corporation to not waste the funds of the corporation?
That's something that we disagree on.
Isn't it much easier to say that the members or directors of a corporation have a fiduciary duty to the corporation as opposed to an outside creditor?
I mean, whether or not it's easier, I think what the Ohio Supreme Court said is clear. It's that there is a duty that arises to creditors and nothing's abrogated it.
But did they say it was a fiduciary duty? Is there any Ohio Supreme Court case or any First District case that says a director or member of a corporation has a fiduciary duty to a creditor of the corporation after dissolution?
I don't know if they've said that if they've called it a fiduciary duty. What they have called it is that it's a duty that's owed to preserve assets, which to me means it is a duty that's owed at that sort of fiduciary duty level that says that I hold a piece of property and it's not for me, it's for other people, right? So to me, that I understand to be the Supreme Court saying that a fiduciary duty exists. Do they use the words fiduciary duty? I don't know, and they may not have.
Didn't they do that, though? I mean, I thought they put $24,000 aside for Mills Fence.
Yeah, and then they paid it to themselves after the
Mechanics lien
after the
expired.
mechanics liens lapsed. Yeah.
Right.
So instead of cutting a check to Mills Fence and just sending the 24.
I thought that there was evidence that they sent them a letter and said, hey, we set some money aside, give us a call.
So that evidence, yes. So there was evidence that they had tried to reach out, but the other evidence was that there had been sort of constant attempts to try and renegotiate the debt over time. And I'm
The
not
debt
sure.
was $24,000. The debt was the
The
amount
underlying
that
debt
they
was
set
24,000.
aside.
They set it aside. The reason they set the debt aside from the sale was that the buyers of the property did not want to enter a transaction with an active mechanics lien. And so instead of resolving
Sure.
the mechanics lien, they set the money aside in escrow, and
Okay,
then
but then they contacted the fence company and said, hey, we have this money.
There was a letter produced that said that they sent it. I think there was a conflicting evidence. I don't specifically recall exactly whether or not Mills Fence said that they remember receiving it. But you're right, there was a letter that was addressed to Mills Fence, and there was no evidence that says that it wasn't received.
Okay.
I was looking at the docket, has any portion of the judgment been satisfied?
No, not to my knowledge, Your Honor.
All right, I'm sorry, going back to the statute, what specific part of the statute are you saying says that there's a fiduciary duty to the creditors by the directors?
Yes, so that would be 170249, which requires directors to apply assets to the payment of obligations prior to the dissolution.
That's the whole shall versus may language?
Yes, yes.
Okay, and you're saying that the shall language covers everything?
Yeah, and I think the statute, I think that that's the most appropriate reading of the statute, that corporate directors they must exercise all of the authority that they have in the windup of a corporation. And then they may use any of these specific powers. One of those specific powers is the application of assets to the payment of obligations.
But the statute itself never says fiduciary duty,
No,
and the Supreme Court itself never says fiduciary duty.
I don't believe so, Your Honor. I'm not 100% certain about that.
Okay, so just also trying to understand the decision below, because, correct me if I'm wrong, though, but the judge did say that if there was enough proof of these loans, these founders' loans, then they would have been right to take all of the money, or are you saying that she didn't? Like, I thought she said that they would have been right in taking the money.
I agree that it's not totally clear. I think that
Okay.
what the law says is clear, which is that they would have been right if they could
Take some of the money.
to take some of the money.
Okay.
And that there would have been some sort of, like, this pro rata sort of, we're going to look at the total amount of assets, we're going to look at the debts and obligations, and if the Kinneys could prove that they had a legitimate debt or obligation that the corporation owed to them, then it would be a portion of that, and then you would, do percentages. I'm not 100% certain what it would look like in practice, but my understanding is that it's a pretty simple calculation, just figuring out proportionally what each of the creditors is allowed to receive. And so, at the end of the day, what Judge Marsh decided was that they just didn't have any evidence of that. Like I said, the revolving line of credit, promissory notes with no amounts in them, and really it amounted to self-serving testimony, which is what the Kinneys wanted to use to say that the debt, and not just the debt, not just the existence of the debt, but the amount of the debt is what they said it was. And that's just, Judge Marsh says that's not enough.
You still have more time if you want.
Okay, yeah, I'm sorry, yeah, I was just.
You have, just under 3 minutes.
3 minutes, okay, yeah. So I think, getting back to this point about the idea of a fiduciary duty and the Supreme Court, the Ohio Supreme Court giving creditors a common law cause of action, whether it's called breach of fiduciary duty or otherwise, giving the creditors a common law cause of action, that's never been formally abrogated by any Supreme Court case. I know Mr. Davidson said that the Supreme Court has affirmed that. I'm not familiar with that, and I'm not familiar with any Supreme Court precedent that has gone back on what Kay Machine said. And in fact,
So the common law authority, it's either K machine under this trust theory, or what is the common law case that gives rise to the fiduciary duty? What other case other than the K machine trust theory?
yeah, so that would be, so there's Gooden v. Cincinnati Whitewater Canal Co., and the Thomas v. Matthews case, which I believe they do use this trust language, but I'm not sure that the trust fund doctrine is all that they're saying there. I think that they may be implying a broader duty, right? And that's the case that courts do cite. In particular, the Danoon case in I believe that's the Northern District of Ohio, cited that as saying that there's a well-established common law duty that is owed to creditors by corporate directors, right? And so they point to these older Supreme Court cases. And I think one of the arguments here was that, well, those are very old and they don't really hold water anymore. But the point is that nothing in the case law has ever overruled those, and the statute didn't abrogate that. And in fact, K Machine, at least from the reading that I presented to the court, K Machine says that the entire corporations code incorporates that principle, that corporate directors need to pay assets upon windup, and there's an actionable cause of action when it's breached.
What kind of fiduciary would you compare these members to? Do you think that they knew that they had a fiduciary responsibility to creditors? Typically, in a fiduciary relationship, the person who is acting as a fiduciary knows they have a special position of trust.
Well, I mean, all corporate directors have a fiduciary, I think it's undisputed that corporate directors have a fiduciary duty to the corporation, right? So I'm not 100% certain that every corporate director always knows what that fiduciary duty entails when they're acting on behalf of the corporation. I guess what I will say is that whether or not they knew that it was a legal duty that arose under this common law cause of action, the Kinneys clearly did know that they had this obligation. And not only did they not pay it, they let a lawsuit against their corporation go into default, which solidified the debt, which became uncollectible, which is why we're here today. And, through all of those processes that, all these different sort of roadblocks that had been put up that where they could have just settled it, there's some sort of duty that, arose, and they were aware that they had a duty to someone to pay, and they just didn't do it.
And notifying Mills that this money was waiting for him didn't go towards satisfying that duty at all?
So I think that goes to what Judge Marsh said with latches and unclean hands, right? And, Mills Fence did not appeal that portion of her decision, but, whether, when you know that you're holding money that doesn't belong to you, just by
But
notifying.
it did belong. They're saying they were owed this founder's loan, so they're saying that it did belong to them because they're being repaid for this loan.
But the trial court said that they weren't owed the money, I think. And that's the key factual finding, is that if the trial court had found, then I think that there maybe, perhaps under a laches theory, there would have been, to Judge Krause's point, that perhaps there is like an equitable theory where they, the equities would have been different and they maybe would have gotten all the money or something like that. Maybe Judge Marsh would have decided that. I don't know. But what she
But
decided.
I'm sorry to interrupt, but don't you need some underlying tort action for this breach of fiduciary claim in this case? My understanding is the argument was this was a fraudulent payment to the directors. And if they were in fact owed the money, it would not be fraudulent. Is that right?
That's right. Yeah, if they were actually owed the money and they actually had produced evidence that they had been owed the money, I agree, this would have been a much different case.
And they produced these promissory notes that they argue was evidence that they were owed the money.
They argued that it was evidence, and Judge Marsh, her factual finding below was that that wasn't enough. And I don't think that that's clearly erroneous. I think that, for, loans of that amount of money, it's not unreasonable to say that, you need to produce a little bit more evidence and say that, there's some evidence of funding the loan and some evidence of paying out the loan.
But is there a distinction between evidence sufficient to establish the existence of that loan in a court versus an understanding of what the directors may have thought that they were legitimately owed? If that makes sense.
I think it does. And I think that, what their belief was as to what they were legitimately owed and going to fraudulent intent, I'm not sure that intent or knowledge really has any sort of bearing on a breach of fiduciary duty. I'm not 100% certain about that. I didn't really research that, so I don't know. The intent issue would be more towards if it was actual fraud. Which and again, I didn't brief the Fraudulent Transfer Act, so I don't know. I don't think actual intent is required under the Fraudulent Transfer Act either. I think it's only if you meet these badges of fraud, which is insider transactions that meet certain sort of, statutory factors that you can infer fraud, right? So I'm not sure that the Kinneys' belief really makes a difference, but that said, I'm not sure what the Kinneys believed or if they actually did believe they were owed that full amount or not.
You are at your
Yeah,
time, so
thank you.
thank you.
Thank you, Your Honors.
Mr. Davidson, I did reserve your 2 minutes, but we let Mr. Schultz go a little bit over, so I'll give you.
Thank you very much, Your Honor. To your question, Judge Moore, the Mills did not argue that this was a fraudulent transfer, and the court had specifically denied them the right to make that argument. So the only argument before the court was whether there was a fiduciary duty owed to Mills and whether that duty had been breached. That's why I don't think we get to the question of whether that founder's loan documentation may have been fraudulent, which of course we would argue it wasn't. More importantly, Judge Nestor, so the Custom Associates 11th District case, which we've already discussed, I would like this court to affirm, does reference 2 Supreme Court cases. So it cites in support of its decision Grube versus Key Bank, which is an Ohio Supreme Court, which then Grube cites Umball Pole Building, which was a 1979 Supreme Court case. And what Grube said, in the past, we decided a debtor and creditor relationship does not generally create a fiduciary relationship. So when Mr. Schultz makes the argument that there's this well-established duty and this well-established common law, my answer is absolutely not. It's long since been abrogated both by statute and by subsequent holdings. Matthews was a very limited decision that was abrogated by statute from the turn of the century. K-Machine is a 1963 decision, abrogated by both statute and subsequent decision. So we get back to your question, Judge Nesser, which is, what are the rights of creditors against the corporation? Against the directors of the corporation. So we go back to 170255J, which preserves the right of creditors to pursue claims against assets of the corporation that have been wrongfully transferred. The statute is very, very specific. There's nothing ambiguous about it at all. It doesn't say it preserves the right of creditors to pursue claims against individual directors and shareholders. It says creditors' claims against assets of the corporation that have been distributed to members.
Well, how would they even do that?
They would file a complaint for a
Like an-
fraudulent transfer.
Like an in rem complaint against the land? Or-
So if there were, so a fraudulent transfer claim can be resolved in multiple ways. I know this wasn't before the court, but you can avoid a fraudulent transfer, so you can recover the property wrongfully transferred. In this case, you can't, because you would have to be recovering the proceeds. And so a trial court would have the ability to recover the proceeds if they still existed, or to hold the directors personally liable for the debt on the basis of the fact that they maintained the proceeds. That was the right claim here. Again, we were prepared to defend it going in. We would have successfully defended it, we feel certain, but that was the claim. When Mills finally decided to try to level that claim, the court said no. And so it puts me in a position where I'm making an argument at trial as to whether there's a fiduciary duty owed, which there has to be based on the complaint, a fiduciary duty owed and breached to even pierce the corporate veil. So there's a lot of misdirection in the appellee's brief about, well, we're not really going after the individual. That's exactly what this is. We have a corporation, we have an entity, it owes a debt.
The corporation isn't even named in this complaint, right?
Correct. The corporation had been dissolved by the time that this came around. And by the way, there were lots of remedies available to Mills Fence when it filed its complaint against the corporation, including injunctive relief against property, forcing a judicial dissolution, intervening in the voluntary dissolution, and getting the court involved. There were numerous opportunities for Mills Fence to pursue its claims when it sued the corporation. The question is, how do you get to the individual directors of the corporation? And the answer is, you get at them by piercing the corporate veil when there's a significant tort that represents egregious conduct, and there's no such conduct here.
The judge didn't find, she specifically did not find that, right?
That's correct. Or you go after the transfer of assets, and that's the underlying allegation in this claim. That's exactly what Mills Fence is arguing. There was a transfer of assets of the corporation that could have been used to pay the debt. That's codified. That's the Uniform Fraudulent Transfer Act as adopted by the Ohio legislature. That's the claim, and that claim was not before the court. And actually, it was just an error for the trial court to even start to do an analysis of that after saying, no, that claim can't be brought.
You are at your time.
Thank you.
Thank you both for your arguments this morning. The case is now submitted, and we will issue a timely decision. Have a good rest of your morning. All right, the next case up is State v. Barker. Mr. Springer, would you like to reserve some rebuttal time?
Thank you, Your Honor. Yeah, I'll reserve 3 minutes.
3? Okay. Hold on, let me get this. I have a fancy timer now.
Okay.
Whenever you're ready.
All right, may it please the court. Your Honor, this is I personally found it a difficult case to determine where to start and begin. So what I'm going to do is begin with Dr. Davis's reports because I think it answers some other questions. First of all, the main issue, I think, that the defense wanted to bring forward in the post-conviction proceedings and in the 60B motion was they wanted to get these reports in from Dr. Davis in an effort to reanimate a claim that was raised before, which is whether or not Mr. Barker voluntarily waived Miranda. And when you analyze and review Dr. Davis's reports, Dr. Davis administered 4 different testing instruments to determine the defendant's ability to comprehend and understand Miranda. On 3 of the 4 tests, one he scored above average, on one he scored significantly above average, on another he scored above average, and on the second instrument that was measured, it was below average but within the standard deviation. When you take Dr. Davis's report and you look at the report that the trial courts and this court, the appellate courts, had reviewed from Dr. Deerdorf, then you start to develop a picture of perhaps why defense counsel did not include Dr. Davis's report when defense counsel discovered in the first post-conviction petition that there was a motion to suppress hearing and wanted to amend that petition with Dr. Davis's report and never did. And so that might be an explanation as to why. That's one point. The other points are procedure. And here we had the first district on appeal did discuss on, I had the paragraph remembered, and Barker wanted 17, paragraph 17 in Barker 1. They did go over the motion to suppress, the voluntariness of the waiver, and so the issues that, or the main issue that was addressed by the trial court in the entry was discussed on paragraph 17 in Barker 1.
But this is, so
That was
you're
remanded.
arguing res judicata, are you? on
That
this?
and law of the case doctrine in a way, because I think with the remand, when the court of, with the post-conviction appeal, the trial court, or this court already decided the very issue that's before us today.
But not with the additional reports, right?
24. It discussed the additional reports. It referenced Dr. Davis's reports.
But it didn't have the reports in the record.
It did not, and I'm trying to explain in a way maybe why. Because the reports, I'm not sure, help the defense.
Can we talk about procedure here?
Oh, yeah.
Because I guess for me, what I'm curious about learning from the state is the 60B.
Yes.
So the 60B was used to set aside the judgment on the initial petition, right?
Yes.
And would you agree that that is a proper procedure to use? I mean, it doesn't seem like you dispute the ability of the petitioner to use 60B. You're disputing the judge's determination on excusable neglect.
Yes. That's my primary argument is because you can't have excusable neglect when the neglect is based upon the action of the party you're accusing of neglect. They completely controlled that. They could have put those reports in if they wanted to. They could have attached them to the petition to vacate. They clearly knew they were present. They knew Dr. Davis' reports were out there.
So what would be an example? I guess what is your definition of excusable neglect, and what would be an example of excusable neglect to be for a judge to be able to set aside a judgment under 60B?
I think it's an extraordinarily high standard. And as I recall, and I just saw our definition here this morning, but it's hard to come up with an example because there's not many where excusable neglect would exist. But I'm thinking more of something where counsel might have missed putting in a report and was untimely because of some sudden illness maybe, or because of circumstances that were beyond counsel's direct control.
What if, like, the attorney didn't even know that the report existed?
That, I don't know. It depends, I think, on the circumstances of that. That's possible that there was a factual pattern.
You're saying in this case it was clearly a tactical decision because it wasn't helpful evidence.
And it's demonstrable that counsel knew about them because counsel said that they wanted to supplement the first post-conviction petition with Dr. Davis's report. So counsel did know about them, but they never did get around to supplementing that post-conviction petition.
Well, they didn't supplement because the judge went ahead and ruled before they could supplement, right?
Well, they had about 6 months, I guess, to supplement, and they didn't offer any objection in the Court of Appeals. This court addressed that issue in the post-conviction appeal
Right.
as to all the options defense had available to it to bring those reports forward. You know, they could have supplemented it within the time frame or after they filed their petition. They could have sought leave by the court to supplement it. I just think, in my view, that's why I kind of started with reports. I think that gives us an explanation as to perhaps why counsel did not want those reports into evidence.
But just getting back to the 60B, so I understand your
Yeah.
position that you don't believe this is excusable neglect.
Right.
If we disagreed, and it would, I'm just trying to understand procedurally, so it basically puts aside the judgment on the first petition. And then my understanding of the judge's decision, and you can correct me if I'm wrong, is that he basically looked at the second petition as an amendment to the first petition and said, this is not a second or successive petition.
Yeah.
It's part and parcel of the first.
I'm not sure about that. I think
That's
that's
what I'm
what
asking.
happened,
Is
but
that-
I'm not sure you can do that. I don't know
Why not?
how. Well, it's a second petition to vacate any way you look at it because there already was a post-conviction petition that was filed.
But is that how
And
you
you-
look at second or successive, or is second or successive after there's a judgment?
Well, there's a judgment, then you get back to a trial court can't set aside its own valid judgments.
But you just told me that a 60B process is it was appropriate if they've satisfied the excusable neglect piece. Like, they can use
No, so
60B
they
to
can
set
use
aside it.
60B, set the first one
That's what you just told me.
aside.
So the judgment's gone.
Yeah, I guess it's just hard because I just don't think you're meeting the standards of 60B at all. It's such an extraordinary.
And I get that, but I'm just trying to understand because, the second or successive petition criteria is very strict.
It is.
Okay? And so that's a tough one for the petitioner to overcome.
So was the first one, too.
Well, the
Not as
second one's
tough.
even harder, especially on a no contest plea.
Yes.
When you don't have a trial. It's very hard to meet,
Yeah.
unavoidably prevented. And so it looks to me like what the judge did, he sets aside the first judgment entry and then looks at the second, not as a second, but as an amendment.
That's what the judge did.
Okay, and so in that instance, because you just told me 60B was okay, was that okay to look at the second as an amendment to the first? And then we look at it as if it's a first petition?
Yes, if you look at it that way, that's what you would have to do is use 60B as your mechanism to invalidate the first post-conviction petition.
Okay.
But I don't know where the excuse would be to invalidate that first post-conviction, but the
Right,
judge came up
because
with
that's your
one.
argument on
I don't
60B.
agree, but yeah.
The only way to do that would be to consider the amended second petition as an amendment of the first, not a second.
You could consider it as an amendment of the first and give them leave to appeal that, I guess. See, that's why it's hard to know where to start, right?
I think we got to figure out, do we even get to the merits, right? Like, how do we even get to the merits of the ineffective assistance of counsel claim? And you got to get through the procedural problem.
And the procedural problem, I think you get through by, first of all, acknowledging that this court already ruled on the issue and the first in the post-conviction appeal. I mean, it ruled on this issue 3 times, to be honest. And I believe you get through it's part of the law of the case doctrine, but the post-conviction, the first post-conviction petition that was filed, when you look at paragraph 24, this court addressed this very issue,
The suppression issue.
the suppression issue and the
So you're
Miranda
saying,
waiver.
though,
It's
if
already
somebody
addressed.
raises an issue on direct appeal, and then they subsequently get additional information, like a report, an expert report, they can't relitigate that issue in a post-conviction with evidence that was never before the appellate court?
Well, yeah, well, in this instance, no, because in this instance, the first post-conviction petition was filed and counsel was well aware of the reports from Dr. Davis.
Right,
And
counsel
had
filed something
every
with the court, right? I mean, it was called like an information of something.
They were
And they
going-
said, hey, judge, we're getting this report, we just found out about the because apparently the suppression hearing transcript wasn't even in the record, or wasn't anywhere to be found. They found this suppression. They said, hey, judge, we're getting this report, you know, we're gonna file something. And the judge went ahead and ruled,
I'm
and then
sorry,
this
did-
court said there was no abuse of discretion in going ahead and ruling.
Yes, correct.
Did they have the report?
They
Or
had the
were getting-
report.
They had the report.
Defense counsel had the report, and that's why I started with the reports, because I think it goes back to this very issue. I think defense counsel decided that, we don't know why, but defense counsel decided not to amend the first petition for post-conviction relief. They had every opportunity to do so because they were aware of those reports. They could have asked the judge for a continuance to rule. I mean, there was a lot of opportunities that were in the control of defense counsel to get Dr. Davis's reports before the trial court for that first post-conviction petition.
But they weren't waiting for the reports to be completed. The reports had been completed, and they were with defense counsel. Is that,
The record is really not clear about that. It's just clear that defense counsel was well aware that there were these reports from Dr. Davis.
well, I guess that gets to my point.
Yeah.
If defense counsel was well aware, that seems to indicate that the reports existed.
Yes, and that's how I think. That's my inference that I draw, that they existed. And the reason I started with reports is I think that explains why defense counsel did not go ahead and amend the first post-conviction petition with them. I'm not so sure they were helpful based upon the testing that was done of the criteria that Dr. Davis used to evaluate whether or not Barker could voluntarily waive Miranda.
And what evidence is there that these reports existed?
Just the fact that defense counsel filed that motion of intent to use them, to amend the first post-conviction petition with Dr. Davis's reports. That's why we know about them. Now, then the trial court rules, and no one seems to, on the defense side, seems to be upset that there was a ruling from the trial court, and as we all know, you know, it could have been something not on the record that, oh, I'm not going to amend it, and it just got on the record. We don't know, but it was in the control of defense counsel is my point. Defense counsel knew the existence of Dr. Davis's reports and could have, as this court pointed out in the appeal of the first post-conviction petition, that there was all kinds of things defense counsel could have done. It was in the control of defense counsel, those reports. That's my point. I think it's very clear that
Defense counsel at least knew what was going to be contained in the reports, even if they hadn't been typed up and finalized.
at some point, I believe so, yes, and that explains very clearly why they didn't amend the petition to me. That kind of, you know, is the missing piece to that puzzle. But we know legally from the record that this court has before, my argument would be, is that it was completely in the control of defense counsel. They knew about Dr. Davis's reports, and they could have amended the petition if they wanted to.
You are beyond your time if you
Thank
want
you.
to
I
reserve rebuttal
appreciate it.
time.
Thanks, Judge. Sorry.
May it please court? You know, it's with a heavy heart that I stand here in front of you because of arguing to you that a very, very good friend of mine was ineffective and that the trial court was correct in finding him so. But the one solace I sort of get from it is the fact that knowing him, he would have been in that trial court condoning what occurred, and he'd be here urging you to uphold what the trial court did. The report did not exist. What had happened, and we need to understand, is in January of 2014, a post-conviction was filed only alleging that the amenability hearing and that the lawyer was ineffective at the time of the amenability hearing. Post-conviction counsel was also the appellate counsel. And it wasn't until May, some 5 months later, that she learned, because the docket never had a denial of the motion to suppress, that it in fact existed. Dr. Davis had only been hired to look at the amenability issue concerning what Dr. Deardorff had put in. In May, after the state, and remember, the state asked for 5 months to reply to the original amenability hearing. In late May, after telling the Court of Appeals, can I supplement with this, it was granted without objection from the state. A few days later, sent to the trial court a notice saying, with intent, I need to amend this. Dr. Davis has not completed the report. When I get it, you're getting it. The trial court could have, if it wanted to, done what every other court has done many, many times and viewed that as a motion to stay, viewed whatever it wanted to with it, and they've done it all the time. Did not.
How long, I don't know if this matters, but curious, how long in between the time that they notified the court that they were working on this report and the time the court ruled? What, I think Mr. Springman said something like 6 months.
No. She filed a notice in May 27. The decision dismissing the post-conviction was June the 30th, so 33 days
Okay.
later.
Okay.
14 days after the state filed its answer. So it was not known for a long, long time. It was not known for a long time. And then within 5 months after that, the 60B is filed, as well as the second, what was titled a successive petition was filed.
Okay, now,
So,
but let's get through the procedure here.
yes,
The second or successive petition,
yes.
this doesn't meet the criteria for a second or success.
agree.
Okay, so we put that one to the side. So the only way we get to the merits in this case is if the judge did not abuse his discretion in granting the 60B and setting the judgment aside on the first.
Correct.
Okay, so how is this excusable neglect?
Well, there are two things, I think, and the reason I'm saying that is this is because the trial court in granting the 60B didn't talk of which of the 5 factors. We're all focusing on excusable neglect, and we can, and that's fine. But also, you have the 5th one, which is sort of the catch-all that could have applied as well when realizing to prevent maybe even manifest injustice, which is that motion to suppress should have been granted and that confession should have been
So
thrown out.
do you agree with the state that this is not excusable neglect, or do you believe it?
No, I think it is excusable
how
neglect.
so?
I think it's because of the fact that there was diligence shown. And I think that that is sort of what the case law sort of talks about, when there is diligence shown. Let's remember this lawyer was working on both an appeal and a post-conviction, and within a matter of coming up on deadlines, found out about the fact that this motion to suppress, and did what? Immediately asked the Court of Appeals, can I amend? And told the trial court, I need to amend.
So they did, so it seems like the lawyer just kind of screwed up a little bit here.
I think
Like they should have filed some kind of motion or something.
And I think in the Court of Appeals, this court sort of talked about that lawyer's neglect. And the question is it excusable given the circumstances what occurred? And it seems that either the trial court in granting the 60B decided it was excusable, and I don't think there's any abuse of discretion there, or unconscionability about that decision, or second, the 5th catch-all sort of provision, which is, wait a minute, I have a 15-year-old kid who reads at a 3rd grade level, and this lawyer didn't investigate that? with the reports? Because that's what's in front of the trial court at that point. What's in front of the trial court is the sort of justifications for why this should be done, because you have to prove that you have a meritorious claim in order to complete your 60B success. It isn't just one excusable, we also have to prove that there was a meritorious claim. So all that is in front of the trial court, realizing that there's a meritorious claim, and this lawyer, and I'm sorry, he fell down on the job. He had an amenability report he could have admitted, didn't, but clearly clued him in his questions, he knew some of it was there because he asked Detective Baldwin a couple questions about, hey, is it St. Joseph's School? That's a school for kids who have learning issues. Hey, he doesn't read so well. And so he's had some of that information, but he just didn't do what he was supposed to do, which was get an expert like Dr. Davis or another expert like Dr. Davis to see that young man and conclude what the trial judge did in 2021. I mean, we talk about, you know, no one here on the defense side, in everything that they did in this case, tried to delay anything. They filed a post-conviction as soon as they got the opportunity to do so, notified the courts as soon as they learned about new information. In response to filing the post-conviction, the state of Ohio asked for 5 months, 6 months, just to file a simple, a few-page response with no affidavits, nothing at all contradicting any of the information. Then when they lost and the post-conviction was lost, the defense counsel filed an appeal, but also later filed a 60B and the second successive with the information that was then before the trial court. All that was sitting there, and the state of Ohio never responded to either one of those for 6.5 years.
So
For 6.5 years.
So the procedure for us to get to the merits is that your argument is the 60B, the judge did not abuse his discretion, and that we consider the second successive petition, which labeled as such, as an amended.
I think it operates, I think by the granting the 60B, it operates as such.
Okay.
It operates as an amended petition, is that what you're saying?
I think because of the fact that when you're vacating, we go back to the day before June 30th, and I think it clearly, the fact that there was filed, you had to label it as such only because of the procedure that was in place at the time, right? The trial court had denied on June 30th the post-conviction. That at least was the status of the law at the time that was on appeal. So anything filed after that would have had to have been referred to as a successive petition. There's no other way to label that. You can't say an amendment because there was nothing to amend because it had been dismissed.
So basically, we have to treat it as something else then, not, because if it is a successive petition, it's barred.
Correct, but I don't think you have to label it.
We're going to call it an amended petition in order to avoid the bar of a second successive petition. It seems like a problematic labeling, sort of.
Well, but the problem is what this court and the Supreme Court and every other court has done, which is the label of the motion is not how you necessarily treat it. People have mislabeled motions all the time, or you ignore that and understand what the purpose of that is. And mechanically speaking, back then, because there was no petition pending, it had been dismissed. The only word you could use was successive. That is it. But if you vacate that first one, you're back to zero. And so the claim.
You can only have a successive if there's a judgment on a first?
Yes,
Yeah.
I think so.
Not-
I think
okay,
that.
So it was
that's-
basically 2 petitions pending.
I think that's the only way you can do that. And so I don't think it's a problem, and I don't think it's to avoid anything. I think that's a proper label of it as an amendment, because now there is nothing that's been dismissed. And,
Can I ask you about the judge's prejudice finding on the ineffective assistance?
okay,
Okay, so the judge says, had the defendant received effective assistance of counsel, there's a reasonable probability that the outcome of the suppression hearing would have been different.
correct.
Is that correct as far as a prejudice analysis?
I think so. I think, and because of, in post-conviction,
plea?
yes, I think so. I think it would be different if it were successive, because then we have to prove that the outcome of the trial would be different. But we have this all the time, where no contest pleas are entered after a motion to suppress a confession or evidence has been denied, and later other evidence comes up to support ineffective assistance to counsel. It's happened all the time. And
But correct me if I'm wrong, but I thought that the question is, well, when you have a suppression hearing involved, first of all, you have to determine, was it meritorious?
Correct.
Which the judge found it was. But also, wouldn't you also have to determine that but for the or the deficient performance of the attorney, that Mr. Barker would not have pled no contest and would have instead insisted on going to trial? Isn't that the answer, or the prejudice analysis? Because, okay, in this case, his confession is suppressed.
Right.
That doesn't mean the state doesn't have any evidence against him. They have two people that were involved in the crime who pled guilty, got deals, and were going to testify against him. So wouldn't we then have to determine, but for the ineffective or the deficient performance, that he would have pled not guilty and would have gone to trial?
I think that's an interesting question, and I'm not sure, and that might be the case.
Okay.
That might be the case.
It's not about, like, would the suppression hearing have been different? Because, like, sometimes a suppression motion doesn't, I mean, there's still evidence left over.
Right.
It might be helpful in your case, like certainly suppressing a confession is helpful. But in this case, it doesn't suppress all the evidence against him.
Right, but what we would always do in granting a motion to suppress, even if there were a trial, and a motion to suppress was granted and it was denied, and an ineffective assistance, and the trial court decided that that were the case, it would vacate the conviction itself. It wouldn't just suppress the evidence.
Now, I'm just struggling with whether he used the correct standard on the prejudice piece.
That I get, that
Okay.
I get, that I get. And I guess it would leave you with the question about, I think still upholding the trial court's ruling on the 60B and that it was ineffective assistance, if you wanted to remand it and ask them to consider whether or not, there should be additional evidence on that question. It didn't hold for evidence. It only held a hearing on the issue of ineffective assistance. It did not ask to hold a hearing for evidence on any sort of prejudice.
Well, ineffective assistance encompasses deficient performance and prejudice.
No, I agree with you.
Right, so he found deficient performance. I just am questioning his prejudice finding, and I'm questioning whether, if I'm right on that's what the judge should have looked at, whether there was even evidence presented below that Mr. Barker would have insisted on going to trial.
Right. And I think you don't have unfortunately, any evidence before you of his guilt other than the fact that he confessed. We can surmise in terms of what people may or may not have been able to say, but that, it really isn't.
There was no evidence that
Right,
these
there's no
people were going to
affidavits, there's no
testify.
filing from the prosecution of affidavits in support of what their evidence would have been had there been a trial, and he had gone forward.
There wasn't any evidence in the amenability piece of things?
Pardon me?
I thought I mean,
Right.
how did I know that there were people that were going to testify against him?
I get that there potentially were, but the full substance of what that testimony would or would not have been, I guess, is what I'm saying is not in there. The idea that
Wow.
people potentially were there, would that have mattered or not? I don't know.
Okay.
I don't know. And so maybe that could also be one of the reasons why the trial court sought that it didn't have to address the idea of the no contest plea, is because there was no other additional evidence that was presented to it that would suggest his guilt other than his confession.
So you think this would be appropriate for a remand if the judge used the wrong prejudice standard?
If that's I think absolutely it would be. I don't think it would be for you to reverse, I think, but you could obviously send it back for that question if that's where the court is. But I think it's real clear that the decision was not unconscionable, unreasonable on a 60B at all. I think the record really, really does support the idea that whatever you want to label her motion notice of intent to amend later on, that demonstrated some of the diligence I think they speak about when they suggest what is excusable neglect. They really don't give lots of examples, and it is rare. I mean, this is not a commonplace, and I think this trial court, in its decision, gives you the idea of exactly how, I would say, how it wrestled with the idea of finding a lawyer of such repute ineffective, and that He didn't take the responsibility of doing so very lightly at all in writing his decision. Like I said, we can talk about excusable, but I also think the catch-all applies. And the 60B entry doesn't state whether it's one or both of those. And I think without us showing that it wasn't those two things, and I think that's then incumbent on the prosecution to show you that both of those things do not exist. And I think in this case, when we have a 15-year-old who was over in juvenile court and then came over to adult court, he was entitled to a better representation that occurred in the case than he got. And there's really good reason to understand why the trial court got to the point they got to for all the right reasons,
Well, you are at your time unless my colleagues have other questions. All right.
No, I appreciate your time.
Thank you.
Very much.
Mr. Springman, you have 3 minutes for rebuttal.
Your Honor, very briefly, when I look at paragraph 22 of the post-conviction appeal, which I guess we could say is Barker 2, it seems like we're litigating the very same thing. When I look at, on appeal, Barker asserts, and then it goes on and basically discusses exactly what we're discussing here today. The other question I have that is bothering me is when it does come to the prejudice prong of the analysis, how do we know that defense counsel didn't make a strategic decision not to use Dr. Davis's reports? The more I look at that, I understand why they didn't do it. Dr.
Wait, that's
Dearborn-
not under the prejudice prong, right? That's under the deficiency prong.
That's under the deficiency
Yeah.
prong. But yeah, I to find ineffective assistance of counsel, I find it very difficult that you can find it where there's pretty clear evidence here that Dr. Davis's reports were not the panacea that was going to win this for the defendant. He scored very well on those tests that showed that he understood the Miranda warnings. He was able to paraphrase it back. He understood a lot of the words and scored significantly higher. If anything, Dr. Deardorff's report probably has more probative evidence in it than Dr. Davis's report regarding the defendant's ability to weigh Miranda, yet that was before the appellate court, that was before the trial court, and that was already ruled on by this court.
So this new report you're saying does not add anything?
It doesn't, and it may hurt, and that's why I think there's not ineffective assistance of counsel. That's kind of what I led with it, because I think it puts some of the procedural aspects into context.
What about the prejudice prong? I mean, did the judge properly look at the prejudice prong here?
Judge, I would point you to the appeal on paragraph 17 of the initial appeal, because that part was not overturned by the Ohio Supreme Court. And in paragraph 17, they did evaluate the prejudice prong and didn't find any prejudice. So they concluded that Barker's counsel was not ineffective during the motion to suppress hearing, and they state all the reasons why. And in there, they referred to also Dr. Deardorff's report, which again, I believe is stronger for the defense than Dr. Davis's. But it's in there.
I meant on what the judge here.
Here.
The reasonable probability that the outcome of the suppression hearing would have been different. Is that the appropriate prejudice analysis?
No, because that's just a conclusory statement. There really is no evaluation of, I know it was a no contest plea, but.
What are we looking at? Are we looking at, but for the deficient performance, he would have pled not guilty and would have gone to trial, or are we looking at something else?
That's not been raised, so
Okay.
I don't think that's what we're looking at. I think what we're looking at is that this issue, one, has been raised already. I think, two, that we're looking at the fact that it might have been counsel's strategic decision not to offer Dr. Davis's reports because they were not that helpful. And that's, so we would ask the court to overturn the trial court's judgment. Thanks for
Thank you.
your arguments today.
Thank you. Thank you both for your arguments this morning. The case is now submitted, and we will issue a timely decision. Have a good rest of your day. Except for Mr. Springman, you're stuck here. All right, the next case up is State of Ohio versus Stokes. Whoa, I guess he's not stuck here.
With the court's permission, I had called the court
Yeah, yeah.
So with the court's permission, I'll be taking over from Ron and standing in where.
If you're feeling up to it, then we're,
Well, if I pass out, then
I hope not.
that will be me deferring my time then.
All right, Mr. Perkins, would you like to reserve some rebuttal time?
Yes, Your Honor, if I could reserve 3 minutes of rebuttal.
Okay, I will, and I keep forgetting to tell people, the yellow light means you have a minute left of your initial time, so.
Yes, Your Honor. Your Honors, I understand that standing before this court with a weight and sufficiency argument, that's not the strongest argument. It's a difficult assignment of error to prevail upon. I understand that you will give deference to the findings of the trial court. However, this court is not required to believe the incredible. And I think this is that one case, this is that one rare case where if the court reviews the entire record, weighs the evidence, considers the discrepancy in the evidence, reviews everything, it will determine that the trier of fact in this case lost its way and created a manifest miscarriage of justice.
So it's incredible as to weight and not sufficiency?
Well, I don't think sufficiency would require the incredible. The incredible, I think, goes to the weight, not necessarily the sufficiency of it. And although it is a sufficiency argument included, I think that the primary weight of my argument is on the manifest weight of the argument, especially as it relates to third and fourth assignment of error, where we talk about the not disproving one of the elements of self-defense, which I believe that does come under the standard of manifest weight. But if we look at this case, Ms. Stokes was convicted of assault. Assault is no person shall knowingly cause or attempt to cause physical harm to another. As it relates to the knowingly in this case, I don't believe that the state met that standard. What her testimony was is that she's in her apartment, she's a single woman, she's alone, she knows she locked her door, she's not expecting anybody, and then her door has become unlocked and is opening. And she reacts, obviously she's scared, and she pushes it closed.
And what did she do after she pushed the door closed?
She locked it.
Did she call the police?
No, she did not.
So the evidence before the trial court is that she felt that an intruder was breaking into her apartment. And then after she shut the door on the intruder, she didn't do anything to respond to that break-in.
Other than locking the door, no.
And then she just went about whatever else
Went
she
about
was
her
doing.
business of getting everything ready to move out. Because that's what she was in
Wasn't
the
there-
process.
Wasn't there evidence, though, before the trial court that she was in fact expecting her landlord? Didn't he
No.
tell her he was coming?
No, that was in dispute. He indicates that he did send her notice. That notice was never produced in court. He never turned over the email that he supposedly gave her notice to the prosecutor.
But the judge believed his testimony, right?
Correct,
Okay.
correct.
So what do we do with that?
Well, I think you have to look at his testimony as a whole to see if you would believe any of it in light of what his testimony was in this case. And that's where I think we get to the incredible part. I know that the state has indicated me that I lambasted him with words, absurd, ridiculous, arrogant, things like that. But I stand by those words, and if the court reads the record on it, I believe you'll come to the same conclusion. First, he talks about his broken wallet, that when the door hit him, it broke his wallet and creased his credit cards. Now, again, the court can use its common sense in that I've never heard of a broken wallet. I was a police officer. I wrestled around with people. I got pushed on the ground. I got hit with doors. Never once have I broken a wallet. Never once have I seen a broken wallet.
I thought he hurt his nose or something.
No, he said his glasses got broke and his head hurt.
What, so, I might understand if it was just he said, she said, but isn't there a third witness?
There's a third witness.
And didn't the trial court basically say, oh, there's a third witness here? There's a third witness who confirms.
There's a
that
there was a
there was
misty-
force and that he was hurt. I mean,
Well,
setting aside the incredibleness of the wallet injuries. she saw the force of the door hit the guy as he was trying to enter the premises.
Correct. However, she did not observe any injuries on him, and her testimony was not in agreement with his testimony in the fact that, for one, she said he fell to the ground. Now, he, who testified in excruciating detail about every little fact of this case, said he never fell, did not testify that he fell to the ground. He told her, he said, I showed Misty my broken wallet and my broken credit cards. She never testified to any of those.
Was there any dispute that the door hit him in the head?
I don't know. It may have, but I
No, I'm
think-
asking, was there a factual dispute that when she pushed the door, it hit him in the head or some part of his body?
Well, I think from her perspective, no, it did not hit him in the head, because she testified that when she pushed the door closed, there was no resistance. She didn't believe that she hit anybody, and that was the end of it.
Well, but she wouldn't be able to see that. So I guess the
She
two
wouldn't be
people,
able-
the two
she-
people outside,
Correct.
was there any dispute that the door hit him?
Both people outside testified that he was struck by the door. But I think what the court also has to look at is the fact that he wasn't there legally. He was trespassing. And the law, there was a lot of things that I will call were creepy about what he did in this case. One is he indicated that he was the owner. From the beginning, he says, I'm the owner of this building, my dad gave it to me. As it evolved, no, he wasn't the owner of the building. He was the son of the owner of the building. He had,
But wasn't he effectively like, the real estate manager for the property? He was the person who was engaged in terms of re-renting it and dealing with the premises and making sure that it was vacated. He was acting
you
as
could-
the agent of his father, even if his father was the owner.
you could come to that conclusion, but even if he's acting as an agent, he's limited on what he can do. He just cannot walk in and out of somebody's apartment at will. It requires that there be notice, that it be reasonable notice.
But didn't she admit that she had noticed?
No.
I thought she basically said, I knew that he was coming, and he had given me these extra days anyway, and I was aware that he was going to show up.
No, in fact, she told him, because when he sent the email to her where he admits that he was at her apartment at 10 o'clock the night before on 2 occasions, then she sent him an email saying, hey, I'm legally allowed to be here to the 4th, respect the law, and don't come around. So she had told him expressly, don't come around to this apartment till after I get out of here, and she had the legal right to be there until the 4th.
And then
So-
his testimony, though, was that he gave her the right to keep her property there, but not to live there, right?
That's what he indicated. However, he gave her the 3-day notice to vacate the premises. And when he was there on the night before, on 2 occasions at 10 o'clock at night, he saw that her stuff was in there. He knew that her stuff was in there, and that's when he sent her the email that was.
That he was going to be there the next day?
He did not indicate in that email that he was going to be there the next day. He indicated that he had come by, and that her stuff was still in there, but he did not give her warning that he was going to come back the next
Okay.
day. So there's not the 24 hours notice that is required by the law. So he's a trespasser coming into somebody's apartment, and what would anybody do if you're inside your apartment and you're not expecting anybody, you're not thinking anybody's going to come in that door, and you see your door unlock and starting to open?
That's
She
the
pushed it-
question in this case, right? If the question is, did she reasonably expect that it was her landlord coming into the door?
And I
Or
don't
did
think,
she think it was an intruder?
I mean, it seems like she knew that he was engaged in this like creepy pattern of behaviors.
which is all the more reason that whether it was an intruder or whether it was him coming in when he shouldn't have been coming in, she had every right to fear for her safety.
Was
So
her
I don't think-
behavior after slamming the door in the alleged intruder's face, was her behavior consistent with someone who felt that they were in imminent danger?
I think so, because if you close the door and you lock it, and that ends the attempt on that person,
then yeah, I think that is consistent with someone who was in fear. She didn't
But
have
the
to be.
door was locked previously, and someone had unlocked it.
Correct.
So
I mean, there was no testimony that he couldn't have just, if he wanted to, he could have just tried again. He had the key. I mean, he's the one who walked away and called the police.
Well, that's even questionable too, because if he claims, yes, he called the police and the police came, but the police never made contact with her. There was no police officer that came to testify. There was no report entered into evidence, and these charges weren't filed until 5 days after this incident happened. So what there's no evidence that the police were there. I doubt police are going to come to a scene of assault and the supposed perpetrator's in this apartment and they don't even try to contact her and then file charges 5 days later. That, like so much in this case, just absolutely does not make sense, and again is incredible.
would you agree that a fact finder could find it incredible that someone would not call the police in response to a break-in?
Well, but I don't necessarily view it as a break-in. There was someone coming into her apartment that did not have permission to be there.
Okay,
We're
let's
not
call it
saying that
that.
her fear level elevated to the threat that this person's going to kill me.
They had a key, though.
Sure.
Okay.
So would it be reasonable to say, okay, this is my creepy landlord's son coming in here again? Could she have thought that? Absolutely, and not called and said, I'm out of here. I'm going to be out of here later.
Isn't that what the judge found, though, as far as knowledge of who it was, that likely she knew who it was, that she
I
didn't
think
it was-
that went into the judge's reasoning. But again, just because she knew who it was doesn't, I don't think, take away the argument regarding self-defense or her fear.
So where did the state fall flat on the self-defense?
I'm sorry.
You said the state didn't disprove.
Correct.
What element did they fall flat on?
All of them. I mean, they would have to prove one of the four disprove one of the four elements beyond a reasonable doubt. One, was she at fault in creating the situation? How could she have possibly been at fault? She's in her own apartment. She's taking care of her business. She sees a door opening and she pushes it closed. She wasn't at fault in creating the situation. The fault lies with the landlord's son, who's creeping around her apartment at all hours, opening and closing her door. Two, did the state prove beyond a reasonable doubt that she did not have reasonable grounds to believe that she was in immediate danger of bodily harm? She's a single woman in her own home, door locked, closed, nobody has a key, nobody should be in here. That was absolutely reasonable for her to be in fear.
Isn't that what the trial court found I mean, I don't know if she said those words, but in essence, she found that she did not have either a subjective or an objective reasonable belief of imminent harm.
No,
Because
she-
she knew this whole apartment scenario was unfolding, she knew the identity of the person, and she knew that his purpose was essentially landlord-tenant related as opposed to an intruder.
No, the court did not go through. As a matter of fact, that's my fourth assignment of error, is that the only thing the court concluded is that the state proved its case, that it met the elements of assault. The trial court never went into, okay, you disproved self-defense. The trial court in its reasoning never even brought up self-defense.
Does she have to, though?
I don't think she would necessarily have to, but if she's reasoning that, okay, the state met its burden of proving its elements of assault beyond a reasonable doubt, the argument from defense is, we're not arguing that this door didn't get pushed shut, but she was acting in self-defense. Yes, the trial court, in my opinion, should have stated which particular element that the state disproved beyond a reasonable doubt. But in going back
You are at your time if you want to reserve some rebuttal time, though.
Okay. I
You're
will-
over your time.
Thank you, Your Honors.
Okay, thanks.
Thank you, may it please the court. I want to once again thank the panel and opposing counsel for moving this on my request. I'll make clear at the outset, unless there's any immediate questions that the court has, that I don't want to get into whether or not the victim in this case is like a creepy guy or whether or not he was or was not the landlord. I don't think that even matters here. I mean, factually, when, as Judge Krause, as you pointed out, this case really comes down to who is the trial court going to believe? Is the trial court going to believe the victim and the independent witness, or is the trial court going to believe the defendant? So which of those two stories is the incredible one based on the totality of the circumstances and the evidence that the trial court was presented with? I think that's the question.
Well, just so I understand what evidence was put in on, because there was discussion about emails that went back and forth.
Yeah.
Where is it this simply the victim's testimony, or was there emails put in?
There were emails put in, and I think really when the court was trying to decide, okay, looking at that subjective or objective standard for a bona fide belief in harm, her claim was that she basically had no idea. When the key hit the lock for her apartment, she had no idea who it was, and she felt she had to go and close the door.
Well, doesn't that make it matter that it was the landlord? Like, that does matter. Like,
Right. I mean, I think the evidence was that the only people who had keys to the apartment, and I do think her testimony was that someone was unlocking the door with a key. There was no testimony that someone was like jimmying the lock or something to get it in. So if and this is what the trial court reasoned, reasonable person understanding, okay, who has keys to my apartment? Me. I'm the only one. That was her testimony. But obviously, the landlord or the landlord's son
But she had
has
told
keys.
him she didn't want him to come in.
And
And she thought I mean, you said it doesn't matter if he's creepy or not creepy, but apparently she thought he was creepy, whether it's the landlord and he rightfully can come in. She didn't want him in there.
That's correct, but I think, so whether he's creepy or not, I think doesn't go to whether or not he should be found credible or incredible. I think
Right.
what I am referring
It goes to her state of mind and that she's scared for,
And to her knowledge, I think her knowledge of him being creepy, even if that was the case, I think goes to her understanding that he is known or has previously come into my apartment before. I think when the trial court is looking at all the evidence and determining, whether or not she knew who was coming in the door, the first place that I would go is the emails. Defense's Exhibit 1, it was sent from him on November 1st. This is the day before at 10:53 p.m. I will be back tomorrow, November 2nd, 2023, to have a contractor assist me in making the repairs. I will be very helpful, and he goes on to say that he's going to be there. He says, I came to see your progress in moving out and the state of the condominium. The next day, he sends her another email in between that time, but the next day at 9:37 a.m., she emails him back and say to that email, acknowledging the fact that he said, I'm going to be there, and said, I do understand, I've told you before, she begins to talk about, in the meantime, you are not allowed to go through my things or enter. To me, that is an explicit recognition of the fact that he said, I'm going to come into your apartment.
so wait, I'm just trying to, sorry, I'm a little slow. The email that said, I'm going to come in, that was the notice for the night that he came, or the
Yes.
morning that he
Well,
came in?
so there's multiple times that he's alleged to have entered.
Okay. And was she there on the other times?
No.
So she wasn't even there?
My understanding of the facts, and I really don't think that any of this is contested, so I'm surprised to hear him say, for opposing counsel to say today that she had no notice of him entering. But I want to be clear about the times he entered and what she claimed at trial that she didn't have notice for. She is a part of the original contract, supposed to stop occupying by November 1st. A fire happens in the apartment complex. He, I guess orally with her, comes up to some determination, and there's some disagreement between the two of them. His understanding, it appears to be from trial, is that she can have until November 4th to remove all of her things, but she's not allowed to occupy the property. Her understanding is, I'm allowed to occupy the property. That's Defense's Exhibit 4
Right.
with that thing. I'm allowed to occupy and keep my stuff in till November 4th.
And in effect, isn't that what her email is saying?
Yeah.
Please stay out?
Correct.
And so then why doesn't she have a subjectively reasonable fear of harm from a person who she is told, don't come in?
And that's what I want. She never said, she says specifically, she's asked at trial, did you think it was him coming in? And she said, no, I had no idea. And that's what the trial court didn't find credible, in terms of that she didn't know. If she had said, and I think really that's what opposing counsel's argument, the argument he wishes he had, which is, if she had got up and testified, I thought this creepy guy was trying to break into my apartment when I wasn't allowed, that would maybe speak more to that objective and subjective fear. But her claim is, we're talking about incredible. She didn't hear anything on the outside. She didn't hear anything during. She just saw the lock turning, and she went up and she just kind of pressed it closed, and she went about her day, and that was it.
But what does it matter? I mean, so if she didn't know who it was, that's really scary.
Mhm.
And if she would have said, well, I did know who it was, but I thought he was creepy, I didn't want him in here, same thing, right? I mean, she still doesn't want whoever it is trying to come into her apartment while she's there. That's a scary thing for a single woman.
I do not get the sense that there was any, I mean, there's been talk about whether or not he's creeping. She did not testify that she had any, and I believe her testimony was to the opposite. She didn't say, I was in fear of my physical safety from him, or I was afraid that he was going to hurt me or anything like that. There's nothing in the record to suggest that he would have harmed her. She simply didn't want him in her apartment, but not based out of a fear of her physical safety, which is the important thing to look at when we're talking about self-defense. In other words, she did not testify that, there's nothing in the record to suggest that, let's assume she knew it was him breaking in. She was like, oh gosh, Mr. Allen is going to hurt me. That is not her testimony. She just didn't want him in the apartment. And not wanting him in the apartment is not sufficient reason to physically harm someone. Not just for the criminal reasons, but
Why not? Like, he's trying to break into her apartment.
I
And she doesn't want him there,
I think you would have to ignore so much of the totality of the circumstances when it comes to the notice that he gives, the fact that he is a landlord, the fact that they have a prior relationship, in order to come to a determination that, to categorize it as a breaking into her apartment. He's using a key to go into an apartment that he is either, the landlord's, he's acting on behalf of the landlord for, and a time that she, at least as he's explained to her, and he does explain to her, it's Defense Exhibit 2, you're not allowed to occupy the property, you're only allowed to have your stuff there.
Are you basically saying the trial court thought she was lying when and that therefore the trial court basically discounted all of her testimony?
Correct.
Because she thought that was a fabrication?
Correct. As I read the explanation of the trial court, and we're talking about, the charge from opposing counsel is that the story of the victim and of the corroborating witness is, as he calls it, incredible. But as you can see from the evidence, the totality of the evidence, he provided her notice. He said, they were clearly in communication about the circumstances for her moving out of the apartment. He sends her a notice saying, hey, I'm going to be there tomorrow with a third party in order to check on the apartment. He shows up with that third party. Both the victim and the independent witness testify. We buzzed the apartment twice. We announced ourselves and we knocked. I used my key that she knows I have to enter the apartment. And as he began to enter, that's when the door was closed on him with sufficient force to knock him to the ground.
What about the concluding argument there that the judge did not go through the elements of self-defense in any explicit way? I know it's difficult for the purpose of review to kind of go back in retrospect, but it seems like obviously she didn't start the affray, so it has to be element 2 that is
Right.
at issue here, right?
Correct. Are you asking whether or not that's the element
Yeah.
that? Yeah, I mean, I think I don't.
Should the trial court have done that?
Should the trial court
Have
have?
done a self-defense analysis so we would know, because it seems difficult to go back after, it seems like they didn't even really talk about self-defense at the conclusion of their trial.
I believe the trial court did go through the analysis. Obviously, as Judge Krause pointed out, the court does not have to state on the record, okay, I'm going through step-by-step analysis. The standard for this court is whether or not the record clearly indicates otherwise. In other words, if something had appeared on the record saying, well, I don't think you properly raised self-defense, so I'm not even going to address it, maybe that would be reason for this court to look into it. But not only is there not anything in the record to suggest that the court didn't go through that analysis, the court specifically references the argument that she had to defend herself, I think is what the trial court says in its explanation.
But the trial court had evidence that she had no business in the apartment in the first place, is that right? Because she could store her stuff there to the 4th, but physically she could not be there.
Yeah, I mean, I don't think that was, I don't think the trial court necessarily had to make a determination about who was in the right with regards to occupation of the premises, but certainly the trial court could have believed, for example, that the defendant there's a world in which the trial court could have believed that the defendant knew she was not allowed to occupy the property.
And that would undermine the self-defense claim.
It would.
as well.
With regards to, so I guess, I don't know if I answered your question, Judge Nestor,
No, you
about.
did. You did.
I think that ultimately, when it comes to the totality of the circumstances, the judge was left to make a determination about who they believe. So to your question, Judge Nestor, about, did the trial court just discount the defendant's story entirely? I feel like it essentially had to pick which story it believed because the two stories are so incongruent. The trial court can't believe at one end that they knocked and announced, and there was all this notice about who it was, and then that the door was slammed with sufficient force in order to knock him to the ground, and at the same time also believe the defendant's story of, I didn't hear anything, I didn't see anything, I didn't feel any pressure on the side of the door, I didn't have any idea who it was. And because I think the totality of the circumstances and the weight of the evidence clearly supported the story of the victim and the corroborating witness, that is the story that the trial court went with. And I think because of that, properly found that the evidence was more than sufficient to sustain a conviction, and also that the evidence was not against the manifest weight. So in that end, I do think that the story of the victim is credible. I think the circumstances and the evidence supports it, and I do not think that any of the assignments of error have any merit to them, and I do think for that reason that the judgment below should be affirmed.
Unknowingly?
Mhm.
So she had to not intend to cause harm, physical harm, but act with an awareness that her conduct will probably cause harm, right?
Yes.
And so we have a single woman in the apartment by herself, and the door opens. Whether she knows who it is or doesn't know who it is, does not want that person in her apartment, and slams the door shut to keep the door closed. How does that meet the knowingly requirement?
Well, I think I want to be careful to make a distinction between her mind state as it might relate to the knowingly element, like actually doing a thing and the reason for doing a thing, and the self-defense element about whether or not her reason for doing that thing was justified.
Okay.
Because you bring up the difference between whether she knew or didn't know. In terms of just doing the act of pushing the door closed and doing that with the intention, knowing that harm can result, I think part of self-defense is that you close the door knowing that harm can
Well,
result.
you admit.
You just do it with,
You
exactly.
You admit to the action, and then you say, well, I did it in self-defense.
Right, and I think that's that there was some argument in the original brief that, perhaps there's a way that she did this almost involuntarily, like, the door's opening and I suddenly close it.
Right.
And I think the distinction that I'm trying to make, and that we make in our brief, is that it's inherently inconsistent to say at the same time that, I have to defend myself, I have to punch out, and that, my hand suddenly flew out towards the other person. Those are two necessarily inconsistent arguments.
Okay.
So our argument, I think, essentially by claiming self-defense, she's essentially admitting that she was
Admitting
doing
knowingly.
the action knowingly. And the case, we cite a number of cases that go against this idea that someone can both do something in self-defense knowingly and do it involuntarily. I think that's the inconsistency we try to point out in our brief.
Good, all right, thank you for that answer.
If there's no other questions, I have nothing further.
All right, thank you. Mr. Perkins, you have 3 minutes for rebuttal.
Thank you, Your Honors. Just briefly, I just want to be clear that, again, my position as to whether or not it was objectively reasonable for her to believe she was in danger, whether she thought it could have been the landlord or whether she thought it was somebody else, isn't even important. I mean, the fact of the matter is, let's assume that she believed it was the landlord. The landlord, yes, read the whole record. He is a person that I would not want coming into my apartment. And she told him, stay out. I can legally stay here until the 4th. Don't come into my apartment. So whether he did give her notice, didn't give her notice, she knew it could have been him, I don't think is relevant at all. The fact of the matter is, she told him, don't come into my apartment, and her door is opening. She doesn't know, she can't see through the door. could she have possibly believed, well, it could be my landlord? Heck, in my opinion,
But if you believe the landlord, he and the person who was with him basically said they knocked and announced their presence. Like, are you saying like she couldn't have heard who they were?
well, I don't, that, I believe her testimony was, she did not hear anything prior to that, because she was getting her things in order to move out. But again, even if, let's say she did, I told this person not to come into my apartment. And he comes into her apartment. And so the question then becomes, is she objectively in fear at that moment that she sees that door opening? And yes, I think it is reasonable, and her testimony.
But why would she objectively be in fear of the landlord who had granted her the grace of using this space, coming in to check the space? Why wouldn't a reasonable tenant in that circumstance be like, oh yeah, it's the landlord coming to check the space?
But again, I think that's, if we look at all the facts that lead up to the whole situation with him coming into her apartment at night, what's that about? Why would you possibly go into somebody's apartment at 10 o'clock at night? And that was in his email to her, that, hey, I came in, and when questioned, why did you come into an apartment at 10 o'clock at night? For one, that's unlawful.
But that was
because
when she wasn't there, right?
I don't know if she was.
What time was this one, when she slammed the door?
What was?
Was it in the morning?
It was in the after. Well, there's some discrepancy about when it happened.
It wasn't at night. The nighttime one was.
Right, the night one was the one.
She wasn't home.
I don't know if she was there or not.
okay.
It's not in the record
Okay.
as to whether or not she was there or not.
I gotcha.
But again, if she knows this guy's coming into her apartment at 10 o'clock at night and then comes in 20 minutes later at 10:20, what's going on with that? And his explanation, you can read it in the brief about why he was coming in there 20 minutes later, is bizarre. So I think she had every right. I understand, Judge Nestor, that, well, it could have been the landlord. Why would she be scared? I think if you read the whole record, you'd understand why she was scared. And the bottom line is, she said, don't come into my apartment regardless. And I think anybody in her situation, seeing that door opening, and on that same topic, I don't think just because something was a reaction, it can't be self-defense. Can you react? How would most of us react to a door opening that we didn't expect to be opening? We would push it closed. That's a reasonable thing to do.
And
I think it could
how
be-
would most of us react to a door opening, us pushing it closed, and being in fear for our lives? How would most people react to that after you shut the door?
Well, again, I don't think she necessarily was in fear for her life, but she was in fear for her safety.
Okay, fear for your safety, how would a reasonable person react to that?
I think it just depends on the person. I see the point that, yes, if you put it shut and then call the police to investigate it. But again, she was in the process of moving out. I can't explain why she didn't call the police.
But at the very least, that was evidence that the trial court could have looked at to undermine her self-defense claim.
Yes, the court could have considered that. But again, I think if we look at those four elements of self-defense, and the court can certainly read her reasoning, but I don't think she talked about disproving that the state disproved any one of those elements. Again, Ms. Stokes wasn't at fault. It was a reasonable belief. It was her subjective belief. And was her force unreasonable? That's about the most innocuous thing you can do if you are in fear for your safety, is to push the door closed and leave it at that. It's
And
not
on-
like she shot through the door or anything like that.
On that point about her not being at fault, there was evidence that she didn't have permission to be in that apartment.
She had permission to be in that apartment. He testified that he gave her permission because he even testified, well, it wasn't fair to expect her to leave because there would have been a fire in another unit and she was.
Right, to keep her stuff there, but she wasn't able to live there. Is that correct?
He knew she was living there. I mean, again, he gave her the 3-day notice to vacate. He testified, I believe, that yes, she was a holdover tenant. Again, I
He
think.
gave her permission to continue to live there past the end of her tenancy.
Yes, yes. So knowing she's a holdover tenant, knowing he's giving her a written notice that hey, you have to be out by November the 4th, that's the date you have to be out by. You have to be vacated on November the 4th. And then coming into her apartment on November the 2nd, after she had told him, don't come into my apartment until after the 4th. Again, I think her fear was objective and reasonable. And I think it's a manifest injustice that this woman is standing here convicted of assault for pushing her door closed.
All right,
Thank
thank
you very
you.
much.
Thank you both for your arguments today. The case is now submitted, and we will issue a timely decision. Have a good rest of your morning.
Thank you.